Good evening. I'm Barbara Benson, and I'm a member of Moses. We welcome you to the Moses Forum on Sentencing Reform. Next week, on Tuesday, March 23rd, will be a follow-up forum with the Dane County Circuit Court judges who are on the April 6th ballot. We hope you will join us for that forum too. If you're not familiar with Moses, it is an interfaith Madison organization focusing on criminal justice reform. Moses is part of a statewide organization called Wisdom that also focuses on social justice issues. We have a full and interesting program this evening. We welcome our online audience watching the live stream. We are honored to start the program with two speakers who have published on the subjects we are addressing this evening, Professor O'Hare and Professor Klingel. These talks will be followed by a series of short presentations from Moses, Nehemiah, and Expo. Finally, we will have a question and answer session with our distinguished panel, Judge McNamara, District Attorney Ozan, Public Defender Doral, and Expo organizer Carl Fields. Our moderator this evening is Fawn Bilgier. Fawn will be assisted by Jenna Raymaker. Jenna will be collecting questions from the audience through the Facebook live chat and relaying them. For those who are hoping to get the continuing legal or judicial education credits we've applied for, please enter a comment on the Facebook live chat so that we know you are attending. Now I would like to turn the session over to our moderator, Fawn.
Thank you, Barbara, and welcome everyone. We'll next hear from our speakers. The first speaker is Professor Michael O'Hare. Michael O'Hare is a professor of law at Marquette University. He has published widely on criminal justice with a focus on sentencing, including two books, The Failed Promise of Sentencing Reform, which explores sentencing at the national level, and even more relevant for us today, Wisconsin Sentencing in the Tough on Crime Era, How Judges Retained Power and Why Mass Incarceration Happened Anyway. This book, Wisconsin Sentencing, is a very readable book, and reading it will illuminate to you how the past has brought us to the current state of affairs. Professor O'Hare describes the battles over sentencing as a competition between four competing ideologies. In his book, he identifies one of these ideologies with the Wisdom Network. That probably gives us the most scholarly recognition that we have ever received. So thank you, Professor O'Hare. Take it away.
Okay, thank you very much, Fawn, and thank you to everyone who's joining us this evening, and it's a real pleasure for me to be with you. The blue line I was describing is giving you 30 straight years of increase. We've had some relative stabilization since the early 2000s, but the number hasn't really come down a whole lot. We're still about 9 times above, as of end of 2019, about 9 times above our historic norms in Wisconsin. So when people talk about mass incarceration, they usually are referring to historically high levels of contemporary imprisonment in the United States, also very high levels compared with international norms. So Wisconsin's imprisonment rate today and the US national imprisonment rate are about 3 to 10 times higher than what you would find in most European nations. So very high levels of imprisonment by historic and international norms. The orange line gives you what I think is an important point of comparison. The orange line gives you the arrests for major violent crimes in the state over the same time period. And you can see for about the first half of the imprisonment boom up to about 1990, those two lines are rising in tandem. So we have a fairly straightforward explanation for why prison populations were rising at that time. Violent crime was also rising, and we were having more inputs into the system. So of course the system is incarcerating more people. But something pretty remarkable happens after 1990. There's a stabilization in the number of violent arrests in the state, but the number of prisoners just keeps going up and up and up and up. So that's a sign of a system that's grown a lot tougher. The numbers of people coming into the system remain fairly constant. The number of people going into prison out of the court system is rising. This gives you a little closer look at some more recent years. Now, the period of most explosive growth in imprisonment is past. That was in the late 20th century. But you can see since 2013 up to about 2019, there is another period of growth in the prison population. So keep that in mind when we get to a graph. I'm going to show you a couple slides down the road. Now, we've got to make note of what's been happening in the COVID world, something pretty remarkable. You can see that since COVID hit, there has been a fairly steady decline in the size of the state prison population. I'm not sure exactly what's driving that. I have some indications that that may be at least in part due to declining numbers of people being returned to prison on revocations. But whatever is going on there, it is important to realize that prison populations are relatively low right now in comparison with the past 20 years. They've dropped below 20,000 inmates. So we're back to where we were about in the mid-1990s. But the number of prisoners still stands about 7 times higher than Wisconsin's historic norms. All right, and this will give you the comparison of Wisconsin with the United States. You can see Wisconsin is the orange line. The United States as a whole is the blue line. And the lines are pretty much following the same pattern from 1960 all the way up to 2012. So mass incarceration is certainly not a Wisconsin-specific phenomenon. It's a U.S. national phenomenon. But if you look at what has happened since 2012, you see something pretty interesting and maybe a little disconcerting. Nationally, the imprisonment rate has been dropping. But remember the slide I showed you a couple of minutes ago, Wisconsin's prison population went through a period of growth after 2012. So in 2016, you see something happening that I suspect has never before happened in history. And that is that Wisconsin's imprisonment rate surpassed the national average. Historically, Wisconsin has always been a low imprisoning state, but no longer. We are now above average in this dubious category. So mass incarceration, as I'm sure everybody in the audience is aware, has become a topic of considerable political discussion in the past decade or so. And that's really been driven by 2 major concerns. One is the cost of mass incarceration. So the first graph shows in constant 2010 dollars that national corrections spending, which is predominantly on prisons, has more than quadrupled since 1980. But the other major driver of the political conversation about mass incarceration has been racial disparities in the prison population. So as Wisconsin's prison population exploded in the late 20th century, as the national prison population exploded in the late 20th century, African Americans were greatly disproportionately affected by that in comparison to their share of the general population. So you can see nationally, there are some wide racial disparities in imprisonment. And in Wisconsin, actually, the disparities are even greater than at the national level. So the big policy question emerging from this political conversation is whether big reductions in prison populations can be achieved without endangering public safety. I think in this regard, it's helpful to take a look at the experience of some other states. I've got here on the slide what has been happening in California, New Jersey, New York, and Michigan, which are 4 of the states that have been among the most successful in the last 20 years in reducing the size of their prison populations. The blue bars indicate declines in the imprisonment rate in all 4 states between 2005 and 2017. And in all these states, as policy changes were adopted, opponents of policy change argued that there would be an explosion in crime rates in these states. Was there an explosion? No, there was not. Quite the contrary. The yellow bars are indicating that the violent crime rates in each of these states actually fell at exactly the same time that the imprisonment rates were falling. Now, I'm not claiming that, and would not claim and could not claim that you can necessarily improve public safety by reducing imprisonment rates. Crime rates are a pretty complicated phenomenon, and it's always extremely difficult to identify the causes of either increases or decreases in the crime rate. But the point is that it is not necessarily the case that crime rate must increase when you reduce imprisonment. Now, we've had some decent reductions in imprisonment in Wisconsin over the past year, but we're in some unusual times now with COVID. One question I think that should be considered is, over the long run, will political will support some different approaches to sentencing in Wisconsin and nationally? And I think there are some hopeful signs in that regard. Since 2012, I have been participating with a couple of other social scientists on a regular series of questions, survey questions of Wisconsin voters through the Marquette Law School poll. And in our survey research, we consistently find large support in Wisconsin for more rehabilitative approaches to sentencing and corrections, and for giving second chances to people who have been convicted of crimes. So the very first question here indicated on the graph is support for giving offenders second chances. 85% support for second chances. 70% of Wisconsin voters say that rehabilitation will help to make rehabilitation of offenders will help to make Wisconsin safer. 2/3 of Wisconsin voters say that when prisoners show rehabilitative progress, that they should be rewarded through reduced prison terms. And 2/3 of Wisconsin voters also say that the prisoners who are safe to release ought to be released after they've served 2/3 of their prison terms. So we see very strong support for more flexible approaches to sentencing and corrections than in the current truth in sentencing laws in the state. This next question from the Marquette Law School poll, I think, also is quite illuminating. We asked the participants in the survey to consider 2 pretty different viewpoints on criminal punishment, and ask them which view they are closer to. So one view is prisons are a government spending program. They should be put to the cost-benefit test. States should analyze their prison populations and figure out if there are offenders who could be safely and effectively supervised in the community at lower cost. And the other opinion here is the more tough on crime punitive opinion. And we find decisive preference for the more flexible approach, which says that prison cells should be used for the most part for the individuals who are most dangerous, and others should be given an opportunity to live in the community. Now, thinking about potential reforms, I think there is one hard reality that needs to be confronted. A lot of people who support sentencing reforms like to focus on the nonviolent drug offenders, and certainly it would be very worthwhile, I think, to have less incarceration of nonviolent drug offenders. But the fact is that they constitute a fairly small proportion of the prison population. And even if we opened up the prison gates tomorrow and immediately released every single nonviolent drug offender from prison, we would still be at a historically high rate of incarceration in the state. The big four driving incarceration in the state are sexual offenses, homicide offenses, assault and battery, and robbery. So violent and sexual offenses. And that's a challenging reality to grapple with. We're not really going to tame mass incarceration until we start to handle individuals who've been convicted of these crimes a little differently because they do constitute such a very large proportion, about 2/3 of our individuals currently in prison. Two pieces of good news here, though, about the potential for doing things a little differently with these individuals who have been convicted of such serious crimes. One is that the data do not indicate that those individuals are especially dangerous in comparison to people who have been convicted of nonviolent offenses. So the slide gives you data from a major recidivism study sponsored by the federal government, really the leading study of recidivism in the United States. The black bars, the darker bars, are the recidivism rates after 5 years for all released prisoners. And the lighter, the gray bars, are individuals who have been convicted of violent offenses. And you can see the recidivism rate is actually lower for the people convicted of violent offenses. You can also see, importantly, that when they do reoffend, it is mostly non-violent offenses when they reoffend. And the recidivistic events of greatest public concern, murder and rape, they're all the way on the right side of the slide. Those are extremely rare forms of recidivism. The second piece of good news is that desistance of people who have been convicted of crimes is the norm. There is study after study after study which has shown that crime is predominantly committed by younger people, and that there is a natural process that applies to almost all people of aging out of the crime committing phase of life. Crime committing tends to peak in the teen years, and then for most people to fall after that. So the graph is showing the results of an interesting study that was done in Boston that followed a group of men from a disadvantaged neighborhood over their entire life course from childhood to age 70. And the researchers found several distinct patterns of offending in this group. But you can see almost all of these different groups begin desistance by the early 20s. The group of greatest concern is what's referred to as the high rate chronic offenders. But even they begin to desist as they hit middle age. That's the highest peak of those three lines. And it's also the smallest group. There are very few high rate chronic offenders. Even they begin to desist normally in the Middle Ages. And importantly, if violent crime is the primary concern, as I think it should be, the high rate chronic offenders are almost all property offenders, not violent offenders. So long-term persistent violent offenders are quite unusual in the criminal justice system. So the evidence suggests that very long prison terms are only very rarely, if ever, justified from a public safety standpoint because of this desistance pattern. And I realize my time is rapidly expiring. Let me just share one other bit of research with you that I think is pretty instructive. Is Fawn, you're telling me I'm done?
You're fine. You have a few minutes.
Okay.
You have 5 minutes left.
Okay, 5 minutes left. Okay, thank you very much. All right. So the very long prison terms are very rarely justified from a public safety standpoint. So what about shorter prison terms? One of the theories sometimes for a shorter prison term or jail term, 6 months, a year, 18 months, a couple of years. Sometimes judges will say, well, this is to scare them straight. This is to send that message that they need to avoid committing more crime in the future. But there are very significant concerns that giving individuals that taste of incarceration will actually tend more often to increase their risk rather than decrease their risk. When you lock somebody up, you're cutting them off from all of the, from whatever positive influences might be going on in their lives, whether it be employment or family relationships or education or mental health treatment or whatever. You're cutting them off from that. And you're putting those individuals in an environment in which they'll be surrounded by a lot of other people who might not be so positive influences. And you may also be cementing in them a self-identity as an offender, as someone who is on the margins of society. So there is, in fact, a fair amount of research that shows that incarceration can be criminogenic, that is to say, risk increasing for many people who are subjected to it. So I have here a very interesting study that was done of 90,000 defendants in the state of Florida. The researchers tried to hold all kinds of different variables constant, offense severity and criminal history and all kinds of other things. And they looked to see for people who are released at different points in time, did they recidivate or not? And what are the odds of recidivism? And you can see that the lowest recidivism rates are actually for the people who serve the least amount of time behind bars. And through that whole first year or so of incarceration, every additional month behind bars is increasing recidivism risk. After year one, recidivism risk tends to fall a bit, but really over the long haul continues to be higher for people released 2 years in, 3 years in, 4 years in, than the people who serve the shortest terms, only a month or 2 or 3 months. So this study, I think, is raising some big concerns about the potential for imprisonment to increase risk and do the opposite of what we want to happen, with this idea that you give somebody a taste of incarceration and they might be scared straight. So just to conclude very briefly, some things that I think policymakers and practitioners should bear in mind, keeping in mind the lessons of some of the research. Appreciate the criminogenic potential of incarceration. Locking people up can actually increase risk. Appreciate that desistance from crime, aging out of crime is a very natural and expected event over time. So long prison terms, and I say here decade plus prison terms, should generally be avoided. And then finally, I guess I'm saying here something that may set up my colleague, Professor Klingel, because this is getting really into her great area of expertise, community supervision. But an important driver of mass incarceration in the US nationally has been people being released from prison, having problems, violating terms of release and getting returned to prison. So that I think should also be a major focal point for reformers. So with that, I will conclude and look forward to hearing from others in the program today.
Thank you very much, Professor O'Hare, for that talk on sentencing and in incarceration. Next, we'll hear from Professor Cecilia Klingel. Cecilia Klingel is a law professor at UW-Madison. She has consistently discerned areas of the criminal justice system that particularly need reform and provided an analysis on how to improve the system. Her recent work includes the limitations of binary thinking about violent crime and the success of parole. Of particular importance to us today is her research on supervision, which includes probation, parole, and the truth in sentencing version of parole called extended supervision. She partnered with the conservative Badger Institute to document the ineffectiveness of long periods of supervision. Over the years, Professor Klingel has enlightened us at Moses on various aspects of criminal justice, and we are pleased to have her with us tonight. Professor Klingel.
Thank you very much for having me back. I'm glad to be here. When Eric invited me, he actually, you're really getting, secretly, you don't know this, but you're getting a double take of Professor O'Hare, because the piece that I wrote last year that he wanted me to talk with you about today actually was invited by Professor O'Hare and inspired largely by his work and many of the things that he was just talking with you about. And that was actually a little piece that I wrote relevant to both those who are incarcerated, those who are on community supervision, and every single one of us. It is a piece called Labeling Violence. It's a short essay. And I think the relevance that it has to the conversation today is to pick up on that point that Professor O'Hare made just a moment ago, that the majority of people who are in prison today, and many of those who are entangled in our criminal justice system more broadly, have been convicted of what are labeled crimes of violence. We find that in conversations around criminal justice reform, there is often public openness and willingness to examine early release, diversion efforts, and other sort of ameliorative mechanisms, right? Ways to get people out of our systems, as long as they haven't done anything too bad or too dangerous, and as long as we don't call it violent, right? You saw that in the polling data, right? Sure, get people out the door as long as they're safe. And how do we gauge safety? Often by looking at the crime of conviction as sort of a proxy for what we think people will do in the future. You already saw on the slide Professor O'Hare showed you one of the reasons why that's not always accurate, which is that many people, rather than being crime specialists, right, always committing the same type of crime, are, like most of us, generalists in the things that we do badly, right? One day you might skip your exercise routine, and the other day you might eat too much Culver's, and the next day you might yell at your kids, right? Like, people who commit crime also don't always commit the same crime over and over. And we find that because violent crime is an aberration, it's usually an exception to a general pattern of human behavior. Very frequently, not always, but frequently, people who commit violent crime don't recommit violent crime. So using crimes of violence as the distinguishing factor is questionable at best. And what I'm going to do today is sort of summarize pieces of the essay that I think might be relevant to your conversation that really look at two different reasons why I think it's important to ask more questions about what kind of behavior we call violent. As I already explained, right, once we've decided someone's a violent offender, we usually put them in a box that's apart from everyone else, both literally and figuratively, right? They may be bound for a prison cell, and also we treat them differently. They are given fewer concessions during the criminal justice prosecution process, often given longer sentences, rarely given access to early release mechanisms, and they are often subject to more of what we call collateral consequences, or long-lasting restrictions that may persist even when the criminal sentence has been served all the way. It's a pretty big distinction. But what do we call violent? If violent crime just meant people who go out and murder others or maim them, causing lasting permanent physical injury, maybe that's okay, right? Because those are, again, very serious and aberrant behaviors. We might want to treat them differently, despite some of the information Professor O'Hare provided, which suggests that actually even folks in those categories aren't necessarily likely to repeat the same behavior. But if we look at the legal definitions of what constitutes violent crime, what you find is that across different jurisdictions, there's actually a really wide variety of conduct that falls under this umbrella of violence. And very frequently, it's not it's not rape and it's not just murder, right? It can be crimes that involve threats of aggression in some jurisdictions, extortion in some places. Professor O'Hare, by the way, has cataloged all the different ways of defining violence in several of his pieces of work. Concealed weapons charges, whether or not the weapon is used or discharged. And in some jurisdictions, operating a motor vehicle while intoxicated is considered a crime of violence as well. So intent to cause harm is not even always a prerequisite for that category. If we're going to define violence that way, and if defining violence in that way means that people get placed in this box of other and separate and different, I think it's important that we stop and ask ourselves how unusual that kind of behavior really is. It turns out it's kind of hard to answer that question empirically. Why? Because most human behavior, including bad behavior, doesn't come to the attention of official authorities. Right? We know that about 25% of arrests are for violent crime in major cities. We don't have any statistics on rural environments that are reliable, and we don't have a lot of information on misdemeanor arrests, but so felony arrests, about 25% are for violent crime. Well, where else might we look? Fascinatingly, the insurance companies have done surveys on road rage as a phenomenon. It is remarkable and terrifying the number of people who concede not only yelling at others and making threatening gestures, but in fact tailgating very closely, close enough to cause an accident, or even bumping the fender of other drivers while driving. It is an astonishingly high rate number. In addition, let's look at domestic violence, which I actually think is one of the better examples, since sad but true, most of us actually behave the worst around those we love the most, right? Although arrests would suggest otherwise, and hospital visits would suggest otherwise, studies ordinarily and reliably show that between 30 and 40% of people will identify themselves as having been victimized by a significant other in their home. Okay. Well, if they've been victimized, someone victimized them, which suggests that the rates of domestic violence are quite significant and high. And in fact, some reports from emergency rooms around the country suggest that official crime victimization reports are probably at least 4 times too low, based on just the number of people who appear with injuries related to domestic violence in hospital emergency rooms. And those are people who are injured enough to go to an ER, right? Imagine the number of people who have shoved or pushed, right? I'm not going to even survey the room or the Facebook crowd. But the reality is that when we look to our own life experience and those of others, what we find is that particularly fleeting acts of violence, shoving, pushing, breaking something, are in fact behaviors that many people manifest at different points in time. As a human experience, violence is fairly universal. The good news, I guess, is that the peak of human violence occurs at a time when we are least likely to be harmful, which is early childhood. Who has not seen a child throw, hit, bite, pinch, right? Sometimes they inflict injury, but usually not of a severe or lasting type. A second peak of violence occurs in adolescence. Not surprising, right? Before our executive functioning can tamp down on some of our stronger emotions. But there are all sorts of conditions in which in adulthood, we can predict that people will be more likely to resort to violence. Some kinds of mental illness, those that affect emotional regulation, for example, are more likely to result in violence, as can challenges in controlling impulsivity, generally, and attention. Dementia in old age can also lead to physical aggression. And if you in fact zoom outside of the criminal justice system and look at bodies of literature about managing unruly and difficult human behavior in the workplace, for the elderly, among the disabled, what you find is that human violence manifests in all kinds of environments where frequently we don't call it violence, right? We don't call it that. When a teenager fights with his or her sister and breaks a cell phone, it's an issue for parental discipline ordinarily and part of adolescence, not a criminal justice issue. And what we expect often in our own lives and those of those we love is that people will mature out of such situations, that their biology, that their environment will change in a way that will keep them from being labeled violent forever and instead become a passage, a developmental moment that we can move them beyond. Sometimes with interventions, right? Mindfulness classes are all the rage these days, right? For controlling our tempers as we are quarantined for a year with our loved ones, right? Might be those kinds of interventions. It might be medication related interventions. It might just be spiritual growth, maturity, education, all of these things in our own families, in our own circles of friends, we typically see as ways to move people past problematic behavior, including behavior that involves physical aggression. But in the criminal justice system, that is not typically how we respond. I think that this matters for a number of reasons. The first is what I have been suggesting most strongly already, which is that when we recognize the universality of human violence, as well as the fact that violence is frequently transient and can be altered and changed across the lifespan, we begin to question whether or not it makes sense to consider irredeemable those people who've engaged in the kind of violence that has been noticed and responded to by the criminal justice system. That's not to say that punishment isn't appropriate, that intervention isn't needed, but rather the question whether that label needs to persist forever is an important one. I am going to offer the pessimistic but very confident prediction that anyone listening to this has told a lie at some point in your life. I bet a lot of money you don't walk around introducing yourself as an ex-liar. Right? We're not forever captured by the bad thing we did. We allow ourselves to move on. And yet people who have been convicted of crimes of violence are frequently labeled and often see themselves, as Professor O'Hare referred to, forever as ex-felons, ex-offenders, that label becomes defining and sometimes can sort of shape and mold future behavior in ways that are problematic rather than in ways that are reparative. The second reason why I think that this matters for people who are interested in criminal justice reform is not so much about people who are subject to our system, but rather about those of us who in one way or another are responsible for its operation. Right? There are psychologists and anthropologists have identified sort of three factors that most affect the likelihood of violence occurring. Those are biological factors, some of those I mentioned, propensities, age, developmental stages, some developmental conditions. Environmental factors, I think that one is the most obvious to all of us, right? There are circumstances in which people may use violence in a protective or responsive way. We call that reactive violence. There may be situations where people have been conditioned to resort to violence first and reflect later, right? Environmental factors can make a difference. But the third factor that is, I think, the most important for those of us concerned about the criminal justice system is that we know that power differentials strongly predict use of violence. This is the reason why some of the people who are most likely to be victims of crime are those who are marginalized or unprotected. So children are often victims of physical violence. The elderly are often victims of violence. the disabled are at high risk of physical violence across the lifespan. They are individuals who are isolated, they're dependent, right? And there is usually not oversight of their lives and their safety, except by those providing care, who are usually the perpetrators of violence against them. Who else might be in that kind of an isolated condition with little oversight? Most people in our criminal justice system, in our prisons, in our jails, right? Individuals in the system are by design cut off. That is part of the punishment, right? They have lost their freedom. They're dependent. They can't easily access outsiders, right? And they are in a position where their power has been diminished. We know that under those conditions, they are more likely to be subjected to violence. And in fact, it is a sad but true reality that when we see acts of violence by police, acts of violence by prison guards, and even the smaller ways in which, whether through physical violence or through simple psychological harm, right? Demeaning people, sometimes even our courtrooms can become places where people are diminished and subject to harms by us, who are not subject to oversight. And frequently we are so busy being concerned about the dangers posed by those in front of us that we forget to think about the harms our system inflicts. And I think it is those harms that explain the problematic outcomes that Professor O'Hare pointed to. The fact that often our interventions increase people's risk of continued engagement in our system and continued victimization of others because we use violence, right? Whether it is essential or not essential, whether it is even if completely justified, think about what we do to people. We lock them in cages. We don't allow anyone other than the state to do that to other people. Why? Well, we'd call it violent, among other things. The kind of sensory deprivations. There are some of our jails that don't provide outdoor recreation space to people who can be detained there for up to a year, sometimes more, right? No sunlight for a year is a harm, right? It could be called a kind of violence. And we certainly know that people tend to decompensate under such conditions. And we could point to many, many other conditions of confinement, aspects of the ways in which we book people, arrest people, speak to people throughout the criminal justice system that may not be intended to do violence, but nonetheless have that effect. And were we to see ourselves as potential perpetrators of violence, were we to be self-reflective in that way, to identify and own and name our own, not only potential capacity, but actualized capacity to do harm, especially to those we deem threatening, scary, worthy of punishment, then I think we would see a very different kind of criminal justice system. It would feel different. It would sound different. We would behave differently, modeling the kind of behavior we're hoping to see from those with whom we are intervening. And it would not surprise me if in such a system, we had very different outcomes than the outcomes that we see today. So those are much more theoretical kinds of reflections than I tend to give in these groups where I'm usually giving you numbers about revocations. But I think it's important for us to step back and think about why it is that we are treating people convicted of violent crime differently, whether it is sometimes, always, never necessary to do what we are doing, when it might be and when it might not be, and how we might be ourselves contributing to the culture of a system that has caused and been complicit with a lot of harm in our communities. Don't mean to be a downer, especially so late at night, but I'm hoping that those kind of reflections, in fact, yield a lot of optimism and hope, because I think they point the way to how we might change our system for everyone in it, including ourselves. That's all I got.
Thank you very much, Professor Klingel, for those deep philosophical reflections. Next, we'll move on to the presentation section of this evening's forum. We'll have 5 presentations. The first will be from Barbara Benson of Moses.
Thank you, Fawn. I am representing Moses, and I feel very impressed with the 2 presentations that I'm following. I find them very thought-provoking, but I will be summarizing some of Moses's activities and thoughts. So for us, the focus of this evening is sentencing reform. And what we're asking of the Dane County criminal justice officials is that the judges and the DAs and the defense bar coordinate to produce a moderate reduction in sentence length and significantly limit the period of supervision. These changes will reduce the jail and prison populations, promote public safety, and decrease the harm to individuals, families, and our communities. These reforms are part of an effort to deal with mass incarceration. And as you've already seen, the United States, Wisconsin, and also Dane County have large numbers of incarcerated people. The United States has the highest incarceration rate in the world. The Wisconsin prison population was over 23,000 in 2019. Dane County sent 433 people to prison in 2019. Justice, appropriate treatment, and even financial impacts demand substantive efforts to decarcerate the correctional institutions and to reduce the unnecessarily long periods of supervision during probation and parole. Decarceration is particularly urgent because of the huge racial disparities for incarceration, both statewide and in Dane County, and the destructive role incarceration plays in communities of color. Over 50% of the people sent to prison from Dane County are Black. We have created a white paper that gives background on sentencing reform. This paper is available on the Moses website, mosesmadison.org, and is part of the material on the Facebook page through which the audience is viewing the forum. I will summarize key points from this paper, some of which have been made with really wonderful graphs and research that Professor O'Hare showed. But in the white paper, there are important points that we have taken from research that's been done on sentencing and sentencing reform. It has been estimated through research that the Dane County jail population, that the Dane County jail could reduce its jail population by 20% through a moderate reduction in sentence length and expediting the processing of felony cases which are in pre-trial status. Additionally, studies have shown such decreases in sentence length do not have a negative impact on public safety. And as Professor O'Hare showed, the white paper also reports on many criminal justice reforms taken by other states that have resulted in increases in public safety. When the sentencing practices in Europe are compared with those in the United States, the European sentences are substantially shorter. There is no evidence that extended periods of supervision protect the community, but there is significant evidence that they can interfere with the ability of those on supervision to successfully focus on work and family. Professor Klingel has argued that periods of supervision longer than 18 to 24 months for probationers and 2 to 3 years for those on extended supervision are not worth the social and financial costs they impose. In reforming sentencing and mass incarceration, it is essential to examine why we, judges and prosecutors, and indeed the community, choose to incarcerate people. What is the desired outcome of incarceration? Punishment, rehabilitation, deterrence? There's also a need to investigate whether the Wisconsin correctional institutions and policies are producing the desired outcomes. We believe that sentence lengths are not driven by data on achieving desired outcomes, but rather are informed by a local courthouse culture. You will be hearing from people with lived experience about some of the harmful outcomes of long sentences and periods of supervision. In addition to examining our values about desired outcomes for incarceration, we need to reframe the debate on public safety so that it becomes one that is not focused on incarceration, but rather a more holistic view of how to promote safe communities. The concept of justice reinvestment has a great potential to promote safe communities. As actions and policies reduce the size of the incarcerated and supervised populations, there will be funding available, for example, from prison closings. That should be reinvested in the community in ways that are more effective than excessive incarceration. If there is a commitment to promoting public safety in the community, investments such as preschool education or substance abuse and mental health treatment will strengthen our community and reduce crime. We ask judges, prosecutors, and the defense bar to engage with community advocates to explore what can be changed in the area of sentencing. Some of the changes will only require a commitment to change courthouse cultural practices. We advocate for a moderate reduction in sentence length and significant limitation to the period of supervision. Thank you.
Thank you, Barbara. Our next presentation is from Sandy Renardi, from Volunteer with Nehemiah. Sandy.
Thank you. My name is Sandy Renardi, and I volunteer with Nehemiah as the program lead for their Court Observer program. We equip members of the public to learn more about the court system through direct observation of court hearings. Our work is driven by concern over Wisconsin's terrible record of racial disparity in incarceration. In our wider public consciousness, there's a lot of media attention on policing and mass incarceration generally, but we don't often hear about the part in the middle where the court process plays out. And it seems to us there is a significant link between the two. Tonight, I'll share just a few of the patterns that have emerged in the observation data we've collected over the last 3 years. As members of the public, most of whom have little to no personal or professional justice system involvement, we have the benefit of having no personal stake in the hearings we watch. We do not consider our own careers or politics, and we are not the ones whose freedom is on the line. We bring a different perspective, that of everyday Americans who are asking the question, is this system upholding the values of fairness and justice that we were raised to believe it should? What most observers learn over time is it's complicated, but I think their experiences can still be telling from the outside vantage point that we take. You'll be happy to know that many people are pleasantly surprised when they first start observing. They find people to be kinder, more compassionate, and more collegial than they expected. But the number one thing reported when people first start observing is that they are shocked by how quickly things move. They find it overwhelming, confusing, and full of legal jargon. Without fail, this makes them question how stressful the process must be for victims, defendants, and family members alike. As they observe more, they learn the flow of different types of hearings and absorb more of the details they hear. Often this raises harder questions. It becomes clear how many defendants have lived lives with significant trauma and a lack of resources. They question the details of revocation and bail conditions that require people with substance use disorders to sustain sobriety without adequate treatment. They notice long lists of charges that shrink during plea hearings. They also notice judges trying to do their best and victims whose lives have been impacted in terrible ways. They see diversion court referrals and are hopeful. They see people unable to complete the requirements in diversion courts and are disappointed. They see that the whole system is messy and difficult. But what we're not seeing is a lot of evidence of the system changing much. And we notice that for all the increase in incarceration, many of our friends and neighbors don't say they feel any safer. It can be overwhelming. We talk about how observers can start to shift that conversation about public safety among their social networks. When people lean toward the easy answer, lock them all up, observers can share that they no longer feel it's that straightforward. What would be amazing as we do this is if people inside the system did this too. If people with greater influence on the flow of funding and the daily decision-making would say so also, that incarceration is not making us any safer, that media coverage is oversimplified, and advocate more loudly for investments in community resources and truly rehabilitative treatment.
Thank you, Sandy. Our next presentation comes from Ramaya Whiteside, a member of EXPO, the group of ex-incarcerated people organizing. Take it away, Ramaya.
Good evening, everyone. Can you hear me good? All right, that works. So tonight I'm just going to discuss from my personal experience the effectiveness or ineffectiveness of a lengthy incarceration. So I did over 2 decades within the Wisconsin prison system, and that included supermax, maximum security, medium security, minimum security, all the way down to community custody. So I went the whole gamut to work on.
Ramaya, brother, if you could lean in, it's more clear when you speak closer to the mic. Thanks very much. Go ahead.
All right. So yes, I went the whole gamut of different security classifications within that 25 years. So I hope that's better. I get a little bit closer. So in 2007, I was eligible from a 47-year prison sentence to be released. I was eligible for parole. And at that time, I was told that release at that time would unduly depreciate the seriousness of my offense. This is what the parole apparatus told me. This is what I was told for an additional 12 more years. This was the main clause of why I continue to be held within secure custody. So it wasn't until 2019 that finally, I don't know what the math was or how they broke that down, but I was deemed no longer to be considered a threat, and I was a viable option for release. So again, I don't know what the formula was. I don't know if they have a specific time factor, but I did at that time close to 20, going on 24 years. And like I said, they came up with the math that it was sufficient. But I want to go back to kind of how it all started. So at the age of 17, I was waived. I was waived into adult court for a marijuana conviction that now is actually legal in many states and could possibly be in the foreseeable future, depends on how things go, be legal in Wisconsin. So in any event, I was waived, and that first incarceration was actually used as a factor in lengthening my second incarceration. So let me explain what I mean by that. So during sentencing, the judge told me, I won't speak verbatim, but he initially said, you were waived into the adult system. That didn't deter you from your criminal activity. You did a small stint in the adult system. That didn't deter you from your criminal activity. So he used that verbiage to basically justify or as his causation to give me the maximum sentence. So I'll say it again, because I didn't get the maximum sentence during my first adult incarceration, he then used that as one of the variables to give me the maximum sentence in addition to the actual offense. So I'm not minimizing the fact that that it was an intense situation, which I was convicted for. I'm just explaining the rationale that he had at sentencing. So at 17, I wasn't given the max. At 19, I was, because at 17, I never received it. So I just want to make that clear, how that all added up. Now, after doing 25 years of incarceration, this is what I can tell you in the audience tonight, that unequivocally, it was not necessary to have me do such a lengthy prison sentence to get the desired outcome if the goal is to hold me accountable and to foster some measure of rehabilitation. And let me explain what I mean by that. So doing more time for the sake of doing time is detrimental to the outcome if that is the goal. So my change process, my maturation process, not only was it just biological, beyond the age of 25, I grew up. That's part of what happened. So beyond that, I still had to do several more years within that environment. So either I was going to have to figure out a way to get it right or give up. So some of the speakers earlier, the professionals, they alluded to the fact that there's a lot that goes on within that setting that really is detrimental if the goal is rehabilitation and to hold us accountable. So I want to make the distinction here. If it is to rehabilitate me and hold me accountable, a lengthy incarceration does not help that. If the goal is just to punish me, then a lengthy incarceration, that's your go-to tool. So I'll illustrate and I'll end by saying this point. Another individual with a similar case as mine, very similar, he did 5 years. He was deemed releasable. Was I able to be released at 2007 and have a measurable amount of success? The answer is yes. The additional time was very traumatic. And if it wasn't for my faith and my support system, I wouldn't be on this call tonight. So I thank you all for having me. Thanks, Vaughn.
Thank you, Ramaya. Hear from Carl Fields, Expo organizer, also from Ex-Incarcerated People Organizing. Thank you. And go ahead, Carl.
Thank you, Fawn. Thank you, Ramaya, for sharing your truth. My story is pretty clear cut as well. I spent almost 2 decades in incarcerated Wisconsin system. The story I'm sharing with you tonight is part of my walk and my climb in community corrections sector. The biggest piece of Department of Corrections, which is that number that was put up on the board not too long ago, was that Department of Corrections numbers incarcerating people has fallen to under 20,000 people. The number of people in community corrections is a bit under 70,000. So the vast majority of the people who are in community corrections or are connected to DOC are in community corrections. So I would hope and would think that there's quite the focus on that, but technically I don't believe there is. That it's a personal opinion, of course, but I spent 16 years in incarcerated, and I too know Ramaya Whiteside from incarceration, and exactly what he's doing now is what he was doing then when I met him almost 20 years ago, which is really saying something. I spent time in max, medium, minimum, made my way all the way down to community custody as well, got out because of the early release program. And I honestly speak to the fact that I am by no means in that low-hanging fruit category, non-violent, low-risk category. All of the metrics that were used said that, either I couldn't be let go or perhaps shouldn't be let go or would be incorrigible. And yet here I am doing the work. I'm 5 years home now. It'll be 5 years, in fact, tomorrow. And the fact is that at this point, I've won multiple awards in my community. I run a shelter here in my city. In addition to being a community organizer, I've received multiple awards that that are along the lines of community asset, et cetera, et cetera. And yet and still, I'm connected to the system in the same way I was from day one. That's problematic in a big way because I sit on multiple boards in my community, and yet I can't fully help the people, whether they be in a reentry category, in a homeless category, in a struggling category, period. I am at a loss to fully help them in a way that I know I can, because I'm not only am my system impacted, but I'm still connected to the Department of Corrections. I'm not even close to even being through my entire community correction sentence, which was called extended supervision. And the research says, and the research around the country is really clocked at three dates: year 1, year 3, and year 5. And the different years says that if a person hasn't committed X amount of crimes or these types of crimes or committed these kinds of infractions after year 1, risk rating goes down. After year 3, risk rating goes down. They stop actually clocking it at about year 5 around the nation, because it's like the rate of diminishing returns kicks in after that. Now, for the most part, we're wasting our time if this person isn't a difficult person. My struggle is that as long as I'm connected to the system, the community as a whole is shaped in a way to say that I'm still not trustworthy yet. So I can't fully engage my community and the people in it to be as helpful as I could be, because I'm still looked at as a problem. If I wasn't a problem, how is it that the system hasn't yet let me go? Because there's a cost involved with me continuing to be connected to community corrections. The pie chart that was put up was very telling to me, in that it showed that the vast majority of the people who are in the system are labeled violent crime, violent offenders, et cetera, and yet most of what we would call off ramps that get people out of the system relate to and are statutorily crafted towards people in the low-hanging fruit category. So in the smallest sliver of that pie chart is where the majority of the statutes are shaped to fit. I myself, I believe that the racial disparities that a lot of people in the system who work for the system, who are in criminal justice also acknowledge that those racial disparities exist in every sliver of that pie chart, every single one. So why isn't that there aren't restorative and ultimately preventative measures shaped for every single one of those slivers in that pie chart? That, in my opinion, serves the public trust the best. That serves the public interest. That creates public safety. And that is certainly something that fits in the restorative justice category to help those who are survivors of crime get their bang for their buck. Because there was a mention of the different polling numbers that exist. And if there's a difference between community majority and political will. If the community majority says that they would love to see something that was the equivalent of parole on that chart to take place in Wisconsin again, the political will of elected officials certainly isn't moving in that direction. And so one of the reasons why, as a directly impacted person who is a community organizer who pushes for what they call upstream policy change, we do this because we are at the center of the work. And we have this saying in our work: those closest to the problem are closest to the solution, but the furthest away from the ability and the resources to do so. And from that, I believe that I owe my community a lot more than just a prison sentence. I believe that the judge that gave me the ability to come home early believed that, and we all still are invested in that because it's a community effort. And with that, I will pass the mic back for him. Thank you.
Thank you, Carl. Next, we'll hear from Eric Howland from Moses.
Good evening. I'm Eric Howland. I'm one of the members of Moses. As you've just experienced, it's compelling to hear from people who have directly experienced our legal system. I cannot achieve the eloquence of those speakers, but I won't attempt to do so. My task here is to focus us back on the underlying themes of this evening as we hand the balance of the evening over to the panel. There really are two themes. The first theme is that the long sentences that resulted from the tough on crime pressure on the legal system were not based on the effectiveness of those sentences to provide the stated goal of promoting public safety. Even what public safety is was not really clear. Let alone do those sentences achieve other goals of the criminal justice system, such as rehabilitation. As Professor O'Hare points out in his book, those of us in the Wisdom Network frame these issues in terms of ethical rather than fiscal goals. It's not that we're adverse to pointing out the goals of fiscal stewardship that is betrayed by the monetary waste of the current system. But our main goal, humane and effective treatment, is not supported by a punishment-focused legal system. The legal system instead overwhelmingly takes people from poverty, incarcerates them for years, producing further trauma, and then returns them to society with additional restrictions, making it difficult for them to successfully re-enter society. Perhaps this theme is summed up by Dostoevsky, who wrote, "You can judge a society by how well it treats its prisoners." A similar challenge from the contemporary legal scholar Francis Cullen states, "In the end, it is essential to test our understandings, including those about prisons, with the best scientific data available. And depending on what the evidence tells us, we need to have the intellectual and moral courage to change our minds and our policies." The second theme of our program tonight is that the current sentencing practices are just that, practices. There are a few laws in Wisconsin that mandate imposing long sentences and long periods of supervision. Rather, the sentences that we see are determined by a courthouse culture. A culture in which the behavior of some defendants is judged to be more suitable for a diversion from incarceration. And similar behavior of other defendants warrants years of imprisonment. We will follow up with these themes now in our panel discussion, which Fawn will now introduce.
Thank you, Eric. On our panel tonight, we have people representing the previously incarcerated, Expo organizer Carl Fields, as you have just heard from, as well as the main players in making sentencing decisions, a judge, Judge McNamara, the head prosecutor, District Attorney Ismail Ozan, and public defender Catherine Dorrell, who's the regional head of the Public Defender's Office. We will ask them some questions, and we invite the public to also submit questions by adding them as comments in the Moses Madison WI Facebook Live chat book. So in the chat book on the page, Moses Madison WI Facebook Live. Jen and Raymico will monitor these questions and submit them as we go. Due to time constraints, we may not get to all the questions, but we will post responses, at least from the Moses team, on the Facebook page, Moses Madison WI, in the near future. So we'll begin with a general question to all the panelists, to all. And I'll ask each of you I'll call on you each individually. It's a 2-minute reaction question. What is your reaction to tonight's presentations? And how do you feel about moderately reducing sentences? DA Ozan, how would you like to take the question?
Well, let me start with this. I mean, I don't think people understand Wisconsin used to be a leader in rehabilitation and criminal justice in the nation. And some of that changed when Wisconsin sort of took the tact of becoming tough on crime. Now, back then when we were leaders, the Department of Corrections used to be an arm of Human Services. And then it became its own state agency and became the largest state agency that we have, with over 10,000 employees, and obviously now supervising about 24,000, it looks like by the numbers, in the adult prison system, about 70,000 in community supervision, and then probably anywhere between, I don't know, 8 to 1,000 juveniles. Now, when we went down the road of truth in sentencing, which had some benefits, which is understanding for victims how long someone is likely to be incarcerated immediately, no one, I think, really took into consideration that truth in sentencing, your extended supervision time resets every time someone goes back into the prison system, which may be a factor. And I'm not sure if those who have been studying the Prison populations or the tract of incarceration in Wisconsin have factored in. I didn't hear that from Professor O'Hare, but I know that they are looking at the numbers. That being said, that really sort of created something that I don't think the general population wanted, which was that a sentence isn't necessarily the sentence that it originally was if your extended supervision continues to reset. I don't have an objection to looking at how we sentence. I think we need to, as a system, be thinking about how can we make ourselves safer? How can we work in a community and make sure that it's safer for all? And I'm very happy right now that we are actually looking at violence as a public health crisis, that we are now seeing public health take on violence prevention. Right now, obviously rolling out their plan here in Madison and Dane County. That I think will bring hopefully new leverage to some of this issue. Now, I think obviously we are focused on the criminal justice system. And as I've sort of described it at times, you're focused at the back of the bus or the back of the train. And frankly, if we're really going to talk about diversion, if we're really going to talk about changing, we need to actually start talking about how can we affect change at the front, at the very beginning, and keep people from becoming victims. Now, I'm not going to tell you that sending someone to prison for a long period of time makes us safer. I would actually argue that it doesn't, but it does serve a purpose. And for victims, it basically puts the person away from them for a period of time. But I don't think all victims want long sentences. I think most victims in Wisconsin want to understand why this happened. Why did they become a victim? How can we hopefully make a change? And if the person is willing to accept responsibility, how can they repair the harm? And that's what I think most victims want. And so I think it aligns well with this discussion. And I've run out of my time. Thank you.
Thank you, DA Ozan. Thanks very much. Next, I'd like to ask Public Defender Doral. Same question. What is your reaction to tonight's presentations? And how do you feel about moderately reducing sentences?
Thank you. I'm really grateful for tonight's presentation. The information presented by everyone has been so thought-provoking. Some of it confirms what we feel anecdotally happening in the system. And some of it makes me think further about ideas that I've been generating in my own head about what we can advocate for to produce change. I believe that asking for a moderate reduction in sentencing is aiming too low. We need to aim higher than that. We need to do better than that. There's a couple of areas that I'd like to throw out there for consideration, which may or may not be the purview of Dane County. These may be more state affected issues, but one is this idea of I guess what you'd call second look sentencing, which is looking at people who received long sentences, whether it's prison sentence or extended supervision sentence, and giving them an institutional opportunity to come and have their sentences adjusted. We don't have any such thing in this state right now, and it's very much needed. The second thing is this issue of losing your street time on extended supervision or having that reset happen, combined with the hidden procedure of revocations involving the Department of Corrections and the Division of Hearings and Appeals, where people are returned to prison on sentences that last years, not just days, years, behind closed doors with no public oversight. Those two things could really reduce these numbers, the big numbers, the people in these violent categories that really need to be looked at and given some grace. That's how I feel about the presentation so far.
Thank you very much, PD Doral. Next, I'd like to ask Judge McNamara, how did you feel about tonight's presentation? what's your reaction, and how would you feel about moderately reducing sentences?
Thank you, and thanks for putting this all together. I apologize to everybody, the viewers, about my audio system. I'm actually sitting in my courtroom right now, which is kind of strange at this time of night, and it's all empty. But the audio system on this computer doesn't work except through the speakers, and so I know that my system has interfered with some of the visual presentation. I'm sorry. I know that partly because my family's trying to watch, and they're texting me saying, "What are you doing to your audio?" So anyway.
I think just fine, Judge McNamara. Thank you. Proceed.
Moderate reduction in sentences is definitely something that people should get behind. And Catherine Dorrell's point that it may not be enough is very significant in lots of ways. But part of the point of that from Jim Austin that sort of launched the Moses Group, I know, into this research, eventually leading to this evening, was Jim Austin's research and presentation to the Criminal Justice Council that you don't have to do major reform to achieve and realize significant advantages and changes, improving the lives of people in the system, and reducing our jail population with all of the benefits that go with that. When Barbara Benson and Eric and others have talked about the courthouse culture, I know what they're meaning because I've had conversations with them. In Dane County, most convictions happen after a plea. About 75% of cases end with a plea. Only 2% end, or less than 2% end with a trial, and about 23% are dismissed, sometimes dismissed because there's multiple cases that a defendant's dealing with, or other factors. Or sometimes the state realizes that the case is not what they thought when they started it. In Dane County, unlike other jurisdictions, most cases ending with a plea also end with a joint recommendation between the lawyers, recommended to the judge, and the judge follows that. Part of the point here is that although each of us in our different positions have our primary responsibilities, a defense counsel can push hard with the client as the client chooses to go to trial. The district attorney's office can refuse to negotiate in some way or other, and the judge is the final decision maker for actual sentences. It actually is somewhat of a collaborative process in Dane County, for better or worse, and it's both sometimes better and sometimes worse. This is different than a lot of other places. Milwaukee County, just by comparison, still Wisconsin, it's rare for there to be joint recommendations. Every little point is argued. Should it be 30 days of jail or 20 days of jail? Should it be 6 months or 9 months? Usually in Dane County, we don't engage in that. We sometimes do. Argued sentences happen. It's happened to me already, this week. I mean, it's part of our normal process. But so working together, hearing from lots of different voices, and knowing the research is huge. And starting to hear from, again, Professor Klingel and Professor O'Hare, and obviously the people impacted the most. I never met before Mr. Fields or Mr. Whiteside, but I know other people who've been affected by the system in other ways. My friend Aaron Hicks and others are part of Nehemiah, and I learn a great deal from them about what my decisions really can do to harm, but also sometimes to hopefully heal. So I appreciate listening to them. I should stop talking.
Thank you, Judge McNamara. Carl Fields, would you like to weigh in on tonight's presentations and your opinion on moderately reducing sentences?
Sure. Thank you, Fawn. And thank you for that, Judge McNamara. As well, DA Zane. I feel that a lot of this is usually broken down in really three categories: beginning, middle, and the end. Pre-trial phase, during serving a sentence, which is either prison or extended supervision, and when we're talking about how that looks, it really falls to a back and forth between a DA and their role and a judge and the court and their role. And there's only so much that either can do, but depends on which times those are. I never want to forget, or I never miss the opportunity to talk about the fact that we are trying our best to both live through and unpack systemic and institutional practices that still show that they are present because of the numbers. The disparities in the numbers reflect that we still have real issues, and those issues, in my opinion, stem primarily around race and economics. And with that, restorative principles, restorative practices. I think DA Ishmael hit it right on the head when he spoke about what victims and survivors of crime really need out of the system. I don't think they and their needs have been elevated enough, in fact, in all of this. And that puts restorative practices front and center when we bring them more into the scenario and not less, and change the whole wording of justice means incarceration and justice means pound of flesh, both for that person and for the community, because it certainly doesn't, not in my opinion. And when we talking about the way that he said it in a way that I hadn't heard before. He said a sentence resetting itself. That's because we have two sentences in Wisconsin, a prison incarceration and a supervision incarceration. But the way that truth in sentencing is set up, it's set up in a way to not acknowledge supervision incarceration as incarceration. So in that, it has the ability to reset. It would be ridiculous for somebody to have a prison sentence reset simply because a person served that sentence but didn't do it exactly the way prison guards or prison officials thought they should. That's ridiculous to anybody who would hear it. But that is, in fact, the case in community corrections in extended supervision. And so we're pushing hard for major reform, not simply moderate reform.
Thank you, Brother Carl. Next question. There's one question for each panelist. Each answer may take up to 3 minutes. DA Ozanne, in light of Professor Klinwell's work, would you be willing to recommend shorter lengths of parole and probation consistent with Professor Klinwell's, well, she didn't talk about her numerical research this time around, but she's also published a lot about her, numerical studies and research, and some of which are described in the white paper that Barbara laid out earlier in her presentation. So referring to those conclusions, would you be willing to recommend shorter lengths of parole and probation?
Well, we don't have parole per se in the sentencing right now under truth in sentencing. You have extended supervision. Probation and parole, or if you're just talking about a straight probation sentence, corrections actually has the ability, they may not use it all that much, but to end a supervision at 50%. Now, Act 28 under Governor Doyle did make a lot of changes to the truth in sentencing system. A lot of that was pulled back out after Governor Doyle left office. But there was, within Act 28, sentence credit for time spent on extended supervision. So actual credit for your time in the community. There was also a number of different avenues of early release within the actual initial incarceration phase of a sentence as well under Act 28. I'm not sure how many people truly understood that. As it is to the length of extended supervision and probation, there have been some revisions to truth in sentencing that have actually addressed some of that. I think judges have also looked at how long does someone need to be on supervision in the community after potentially a significant prison sentence. And I think sometimes they may also look at a shortened initial incarceration with a longer extended supervision. That still doesn't get around the issue of an extended supervision sentence, frankly, resetting, which could put somebody in the situation where they just never have a real ability to get out from under supervision unless it's day-for-day prison time spent in the institution, which I don't think is something that the community truly wants. I think the community does believe that you can safely supervise somebody in the community. And I think if you gave corrections the ability to review a lot of that and make modifications where possible, you would give people an incentive to, I think, do better, stay engaged, and stay out of the criminal justice system. But if you create a system that basically sets them up, or they feel they will never ever be able to get out from under, you do take away some of that hope and some of that motivation to hopefully conform to what society wants people to do, not create crime, and hopefully get a job and live with their family and loved ones and have a piece of the American dream, where they can buy a house or a property or have nothing else saved for their retirement or their kids' education.
Did I understand correctly, DA Ozan, you're intimating that part of the issues with the sentencing, resetting, and so forth lie with at the legislative level, either or the executive from the executive branch, Act 28. I'm sorry, that comes from, that's beyond your particular office. Is that what you were saying?
Well,
Under
if
constraint-
you want to change the sentencing guidelines, if you want to change sentencing at all, there was some discussion in some of the presentations about, frankly, discretion of courts, discretion of prosecutors. That is one issue that people point to as a big issue within the criminal justice system. I would argue that discretion is needed. But if you look at Minnesota, one of the reasons they compare us because of demographics, but Minnesota has lived under sentencing guidelines for 20 years where Wisconsin is not. But there are some offenses in Minnesota that the courts just can't send someone to prison for. I would not say that their system is better. I would say that it's different. I would think that there are issues in both that we should probably look at and learn from. But if we're wanting to recommend shorter extended supervision times, I think that actually those discussions are happening. I think they're happening with the courts as well, and judges aren't creating extended supervision sentences that are astronomical. I think when Truth in Sentencing first started, there were very lengthy sentences. And I think that came from the old system where in probation or your old sentencing, you would sentence someone to 20 years in the Wisconsin state prison system. The judge knew that they would be eligible for parole in 8 to 10. Likely, if they weren't out at 8 or 10, they would be out by 12, and the rest would be on parole. And that sentence would be done at the end of that length of 20 years. Truth in Sentencing does not have that because it can keep being extended because of the ES resetting.
Okay, thank you very much, DA Ozan. Next, a question for PD Doral. Public Defender Doral, do you feel the balance of power between the DA and the defendant work together to create an optimal sentence for both the accused and society? 3 minutes, please.
That's a great question. I think the balance of power between the defendants and the world creates problems. If you come into the criminal justice system as a defendant and you have money, health insurance, prominent people in the community on your side, the opportunity to pay restitution while your case is pending, the money to get into a treatment program while your case is pending. That all makes a big difference into how your case is processed in the criminal justice system. So I think that's the number one disparity that is just there. It's just a fact that's in the system. There is a disparity between resources. My office we do what we can. We're a triage office. You ask any public defender office in the country, they're going to tell you you're a triage office. You do the best you can with what you have. We could use a lot more investigators. We could use a lot more social workers. Frankly, we could just use a lot more help with things like answering the phone, filing, things like that, that we just don't have anyone. The lawyers are doing that. Downloading the discovery materials off the internet. The lawyers do that for all their cases, which takes sometimes hours a week to do. So in that respect, there is a resource imbalance, but I would say that the greatest imbalance is that clients who come into the system who have the resources to put themselves in a better position in the eyes of the DA's office and the court do better, regardless of the representation they might have.
Thank you very much, PD Doro. Next, Judge McNamara, in 3 minutes. Do you feel the plea bargain and joint recommendation process works well for both defendants and society? And is this evidence-based?
It's really important to look at the plea bargaining process. It's a major driver of what we do. When Sandy Bernardi and her group of court observers emphasize how quickly things happen, she's primarily talking about plea hearings that happen very quickly. Judges have to say certain things at a hearing, and we sometimes, pre-COVID at least, are doing a lot in a relatively short time. I did want to say before I can directly answer that, Catherine Dorrell's office is perhaps triage, and I know they're understaffed in many ways and under-resourced, but some of the best trial attorneys in Dane County are the public defenders. They are real trial lawyers, almost all of them, and that's an important part. And it counterbalances this plea process. When we ask, are plea agreements good for people, for the system, for the community? You have to also kind of wonder, well, what would be the alternative? Bad pleas are bad. A plea that is coerced is bad and unjust. Coercion happens when someone pleads to get out of jail because they can't post cash bail. Coercion happens if they feel like they can't get a fair trial. And coercion happens when they feel like if they go to trial, they're going to get a penalty from the judge, that the judge is going to hammer a sentence that they could have avoided if they just had entered a plea. Those are all bad pleas. Those should never happen. But we do believe our goal for a plea is that it's knowing, that is, that the defendant knows his and her rights, they know some of the issues of law, they know the facts of the case, and they know the risks of going to trial as best they can be explained by a good lawyer. And it's an intelligent choice. It has to be knowing and intelligent. That is, it's a reasonable choice to go to trial or to enter a plea. But the biggest component of a plea is that it's voluntary. It has to be freely given. That doesn't mean happily given. It's not what people want, but it has to be a voluntary choice. And that's why I focus on coercion. It's a breakdown if a defendant is coerced. One of the driving factors that I'm learning from research by people like Megan Stevenson and Jennifer Doliak, economists who write on criminal justice and reform, emphasizes the role of misdemeanor cases in driving prison sentences on felonies. And there's a disparity that happens in different populations, racially, economically, that people collect misdemeanors and then appear in front of a judge on a felony charge and look different than someone who doesn't have a bunch or stack of misdemeanors. And they have a different outcome, more likely to get some prison. And so there should be more trials on misdemeanors, but they do have to be fair trials with reasonable outcomes. And that's a whole bigger discussion. But when pleas are voluntary, when a defendant says, I committed the crime to which I'm pleading, and I accept responsibility, and I want to accept the consequences for this, and hopefully you haven't given up on me and labeled me forever. But when that happens, it actually can be a positive outcome, and people can make change and move in a better direction. Thanks, Tom, for fun.
Thank you, Judge McNamara. And lastly, to Carl Fields. Now, we've heard evidence that long sentences of incarceration and supervision can be harmful to the directly impacted person, as well as their families and the community. Do you care to say anything more about this in 1 or 2 minutes?
Yes, I'd like to. Personally, I'm on supervision for at least the amount of time that I spent in prison. So with that, the fact that we have a system of community corrections that does not count unless I do all of it and do all of it exactly right is extremely problematic for me. And it adds to any and every sort of piece of stress that I have in my life. That adds to the toxic stress, and it adds to the community health numbers that were mentioned earlier. That's a public health issue when we start talking about quality of life, and that quality of life being very low in the neighborhoods that I'm from. So if you look at the public health numbers alone, I guarantee you everywhere that you see bad numbers, you'll also see high criminal justice numbers, because they go hand in hand for a number of different reasons. And one of those things for me is just that the biggest thing that you build once you've done time, because the community feels you've done your time and served your sentence, is you have a certain amount of social currency given to you. When that social currency is snatched from you for reasons that ultimately are proved out to be incorrect or just don't make sense, not only is somebody released from an alternative to revocation or an ATR, as it's called, not at neutral, but at negative, but they're even in a less position to build back than they were when they started. And their freedom and everything else was snatched for reasons that don't make sense. It's not mandatory. It's not a requirement that a person is incarcerated while allegations against them are investigated. That's a part of the revocation piece that the DA referred to. And I get that public safety is huge, and I get that we want to protect people, but we need to take the politics part out of this, and we need to be looking at the fact that we are losing real human capital by the investment. We are losing the fact that we are not in, this is not a good investment to continue to do criminal justice this way. We just are not getting the bang for our buck if the people who are going into the system aren't being brought back better, and the people who want the people to go into the system aren't getting their needs met by the way it currently operates. So
Thank you for that characterization of the feeling like revocations and the terms of extended supervision. It sounds like they can sometimes feel arbitrary and can end up more detrimental, is what you're saying, to the people who are impacted. So next question, and we'll just narrow this down to 90 seconds. What do you think should be achieved by incarceration and supervision? And are you seeing the results you want? 90 seconds, Judge McNamara.
So one of the negatives about my job is that I rarely see outcomes of my decisions. I don't get feedback. People don't write to me. I don't get reports from the Department of Corrections or the District Attorney's Office or anybody else. There's no such job that says, you sentenced this person and this is what happened. I do see when I place someone on probation, if they're revoked by DOC in those closed hearings, as Doral mentions, they come back sometimes for sentencing, and that looks like it didn't work, perhaps, but that's a tricky definition. It's complicated in terms of what's achieved, and each case is a little bit different. I do believe that people can change in positive ways by different outcomes, and usually it's kind of treatment and some supervision, and that is most of our dispositions. Not everybody automatically goes to jail, or certainly doesn't go to prison right away. And although, as Barbara mentioned, I think 433 people went to prison from Dane County in 2019, that's substantially down from 2008, when 785 people from Dane County went to prison. That's a huge drop. Thanks.
You're muted, Fawn.
I'm sorry. What do you think should be achieved? I'm sorry. DA Ozan, what do you think should be achieved by incarceration and supervision? And then I'll ask, are you seeing the results that you want?
Well, I mean, I guess that's hard. What I would like to see is that we don't have victimizations. I would like to see us creating opportunities for people so that they are not violating the law or hurting the ones they love or hurting other citizens. So, you know, at some point when we're talking about violent offenses, you know, some of what the system does is take someone out of the community to separate them because of the behavior that we are seeing. And at some level, maybe that is all we can expect. Now, I think the Department of Corrections actually can work well with employers in the community, can train people. But the question is, are you able to get somebody a life skill while you have affected their liberty? If you can, so that they, when they are released, they can actually have a living wage job, I think you've probably done, you've given somebody a benefit. I am not saying that you truly benefit anybody from incarceration. But when we have a system that we have, sometimes the only thing we can do is take somebody out of circulation for a period of time to stop the victimization. Now, I would hope that if we really are serious about reforming the criminal justice system, that we start much earlier and we make sure that we aren't having children be victimized, because that's one thing that I think I can tell you I saw when I was at corrections as deputy secretary, was truly that a consistent swath of the population had childhoods that were littered with abuse and neglect. And if we could stop that, I think we would stop the flow into the prison systems almost immediately.
Thank you very much, DA Ozan. PD Doral, what, in your opinion, should be achieved by incarceration and supervision? And are you seeing the results that you would like to see?
Well, I think any criminal justice intervention should be a launch. It shouldn't be a completed journey. And what we do for a lot of people in the system is we identify 50 problems that they have, and we say, you have to address all of these before you're done here. And that's a recipe for failure. If we could just identify one or two things that is going to push them and launch them in the right direction, make it doable, have the right programs and people in place to make that happen, then I think we could be much more effective. Right now, the programs we have that do that are completed by people who, in my opinion, in my experience, really didn't need the program in the first place. They would have self-corrected and they didn't need all that help or that intervention. So that's sort of my view on that question. Thank you.
Thank you, PD Doral. It sounds like you're taking an engineering approach to things. Let's narrow down the problems to solve and address them one by one or few by few, rather than all at once in a big pot. Well, that's what it struck me anyway. And so next is the question. It's a pretty straightforward question, I believe. It's a 1-minute question. Are you willing to engage with other players in the sentencing process and members of the community to explore moderate reductions in sentence and supervision lengths? And I'll start with DA Ozan.
I would say yes, I am willing to talk to people. I've tried to do that. I've tried to look at the system differently. We actually got the reentry court with the Department of Corrections up and running here. I saw the Harlem Reentry Court and thought that we could actually do that in Wisconsin, and that did become a reality. I can't tell you the numbers that they have right now, but they are also using that to keep from sending people back into the prison system. Which I think is good, but I think we need to have more resources to help reconnect people into the community with accurate avenues to basically have what is needed to have a successful life.
Thank you, DA Ozan. PD Doral. The question-
Absolutely.
Yeah,
Absolutely. My
willing to
answer-
engage with other players. Yeah, go ahead.
My answer is absolutely. People like the DA and the judge and I, we see each other all the time at meetings within the system, and we have conversations, not with just with each other, but with a lot of other people. And I've engaged with Moses before on several occasions, and I would be happy to keep doing that. And with any other group that wants to hear my thoughts on things and give me ideas as well.
Great, thanks very much. Judge McNamara, you have partly already answered this, but are you willing to engage with other members of the other players in the sentencing process, as well as members of the community, to explore moderate reductions in sentence and supervision lengths?
Yes, absolutely. And just as Catherine Doral said, you know, like I was going to say exactly the same point, that the three of us are often in meetings together. I probably need to do a better job of listening to both Catherine and Dish, and listening to people like Mr. Fields, and not talking quite so much when we get together. There are some people who think, nope, judge, you do your job, DA, you do your job, defense counsel, and if you do your job, the system will work. Those are siloed, boxes, and I think we do need to discuss and collaborate different points of view, and figure out what's working and what's not. Dane County has a lot of criminal justice challenges or problems or defects or biases and disparities. I mean, there's however you want to label these, and they're all of those would fit. There are some things that are working okay. We're doing better. We don't incarcerate people for not paying their court fees. We're doing pretty good on cash bail, but we can do better. And listening to the people that are affected by this is usually the best way. But there's change to be had, and if we listen to each other, I think it can happen.
Thank you, Judge McNamara. Now I'm going to thank you very much. To me, it sounded like there is a lot of issue of resources, and partly this has to do with the political will of us as a society. It sounds like how do we allocate our resources, and how, to what end, and so forth, to have this larger conversation. Speaking of larger conversation, Jenna is on the Facebook Live chat, and I'd like to hear from you. How's it looking over there?
There has been so much interest in this topic, and a lot of comments, a lot of questions. We've had over 60 attendees, including numerous other judges involved in the Facebook audience. And so I'll pick out two questions here to ask to the group. The first, I think, is a little bit more philosophical, because I think this change would have to occur at the legislative level. But would you support going back to sentence lengths from before truth in sentencing, when that, of course, gravely changed how sentence lengths were applied? And if not, I guess what would be some of the considerations for why not?
Thank you very much. Since we're running close to the end of our time here, let's keep it to 1 minute if possible. Thanks. Would anyone like to take field this question? DA Ozan, for example?
Well, I think you have discretion within the judiciary to set the sentence lengths. I think working within the context of truth in sentencing and extended supervision is something that should be discussed and probably taken into consideration. I think some of what you saw, the impact of truth in sentencing, was because the same sentence lengths that were used in, say, old law were originally brought over into the truth in sentencing world. But they don't equate the same when they play out in truth in sentencing versus in old law. So I think the discretion is there by the judges. I think it should stay there. And I think that these discussions will help inform them as to how they sentence. But that's also a discussion for the legislature as well, if they want to make sentencing reform.
Thank you very much. Judge McNamara, your thoughts?
The challenge for sentencing from the judge's point of view is that I have to make a decision at the sentencing about who that person's likely going to be maybe many years out. And it's humbling, it's impossible, it's almost ridiculous, to be honest. I never have been a judge, and I didn't work in the system before truth in sentencing. I know there was a lot of uncertainty by everybody, including defendants. How long will I have to actually be incarcerated? And some of that uncertainty was not good, but you know, I sure wish, you know, well, I think what it requires is just, you know, being very, very careful about long sentences, because it's really difficult to predict, you know, that a person is not going to change within 3 years or 5 or less. And so let's be careful. But yeah.
Thank you. Thank you, Judge McNamara. PD Dora, your thoughts?
As flawed as you can say it was, I would go back to that structure in a heartbeat. I practiced before we had truth in sentencing. Sentences were shorter. They were incentive based. They were based on the idea that people have the capacity to change, and it made people want to change because then they might get paroled. That is how I would like to see any system of caging people, an opportunity to prove that you can get out rather than a simple, I'm sitting in here until this date certain.
Thank you. So at the risk of going over, we do have a program next week at this time. I mean, at 6:30 next Tuesday for the second part of the second forum in this series, for which we hope that everyone will join us in the same Facebook Live login credentials and so forth. If anyone has patience for one, would you like to bring up one last question or a summary, Jenna, from the Facebook Live?
Yeah, if people are willing to take one final question, which I think can then wrap up the evening. Given what we know about lengthy sentences being both expensive and having diminishing return on an investment from a public health or from a public safety standpoint, what do you think is the biggest barrier to having more people like yourselves, you and your colleagues, trying to reduce those lengthy sentences?
DA Ozanne?
Well, I wouldn't say that we aren't trying to reduce some lengthy sentences. I think some of the violence that we are seeing is, frankly, the gun violence is off the charts. And, you know, there are many ways to address that. And I think, you know, working with somebody at the back end where we are, that is hard. It's hard, as the judge said, to know how that person is going to be, you know, 5, 10, 15 years from now. And you hope that you can create within the system an ability for the person to, as Catherine Doral put it, have incentives. And those were there, those were put in there in Act 28 under Governor Doyle, and they are no longer there. They did have an ability for someone, frankly, to be sentenced and to, if they worked through the system, be off of supervision in 50% of the time in some instances, which is much different than what we actually have today.
Thank you, DA Ozanne. Sounds almost as though you're suggesting or continue that some of us who are interested could lobby for or advocate for a return to that Act 28. Maybe that's something we can ask our lawmakers about. Judge McNamara?
I'd like to try to help my colleagues know some of the research that's been talked about tonight, and it's contained in the paper from Moses that they worked hard to put together, and it's well researched. I think if more people like judges and DAs and defense lawyers know of things like from Professor Klingel's work that 81% of people who find themselves revoked on supervision will likely be revoked in less than 24 months, and therefore we don't need 5 years of supervision because it's just not reasonable or necessary. That I'd like judges to know about that, and some of them are here listening, and some have had exposure to this, and we need to educate better because there are researchers. Without that, without the research, which is really important, I prefer to listen to people like Mr. Fields and would like to know if he had thoughts about length of sentences from the perspective of a person who's been sentenced, if he wants to.
Thank you. On that note, I too would like to hear from you, Carl Fields. What's your opinion on this?
I think a lot's been covered. I think we're talking on ramps and off ramps. We're talking charging and in some cases overcharging. And that's directly in the DA's hands, depending on what the case looks like and those elements, et cetera. When we're talking about sentencing and discharging, you know, to some degree that can be considered an off ramp, and how that's carried is or at least can be a huge thing. But I think the DA was spot on when he was talking about it being in the legislature's hands, and it's an infrastructure change. It's a huge change, but in the meantime, we're talking about, like Catherine said, triage. We're talking about two pieces of the system, the judge and the DA having the ability to exercise their positions to create off ramps so that discharge can happen, so that restorative pieces can sometimes happen, and not just happen in that small sliver of that pie that I talked about. But there's a phrase called that they use referring to people like myself, subject matter experts. There are a lot of people that I know who get paid a lot of money to fix a lot of these problems, and then they call me. They don't hire me for these jobs, which is a systemic thing, but they will call me to help create the platform on which to walk to do this work. That is a systemic thing all day long. And that is also something that a patch can be created to help me do that work, because until I'm discharged from the system, I literally can't take the job in some instances. And that's ridiculous, because they say we want real justice and we want real reform. And I'm also acknowledged by the mayor himself by standing ovation that I can be part of that process. I can get a phone call from him, but I can't get a tangible off ramp created for me. That's problematic.
I hear you. Thank you for laying that out very clearly, Carl Fields. And PD Doral, any last thoughts on this matter?
No, I'd like to end with Mr. Fields' comments.
Great, thank you so very much. So, and I'd like to just underscore what you alluded to, Judge McNamara, the need for, we have research, but not only having additional research, but incorporating that research into the practices of daily workings of the criminal justice system and what you all do each day, and bringing more best practices and evidence, and so for evidence-based practices. So I will point to you all that there is a white paper on the Moses Madison website that you can link to it there, and that it contains some of Professor Klingel's research, and so we can continue this conversation even after this tonight. I would like to thank the speakers and panel members for their participation this evening, and to the over 60 people who are watching online. We thank you also for your interest and hope that you will join us next week on Tuesday night for another Moses-sponsored forum. 6 of the Dane County judge candidates on the April 6th ballot will be on the panel, and there will be an opportunity to ask them questions. So again, we thank you for your attention and concern for the matter of criminal justice and racial justice and true justice and restoration of people in our system and our family, for safer, healthier families and communities and individuals. Thank you very much, and good night.